Hello everyone and welcome to week 3 of Poll 101, American National Government. This week is all about civil liberties. The civil liberties are the political freedoms that protect individuals from the abuses of power by the government. And where do these liberties come from? Well, they're the first 10 amendments added to the Constitution, known as the Bill of Rights. Now this week, we're talking all about civil liberties, and next week we're talking about civil rights, but there is one important distinction that I'd like you to be aware of moving forward in this class. So civil liberties protect us from the government. You can kind of think about it in terms of this figure here on the left. There's a gate that protects us from the government. These are our civil liberties. They're untouchable by the government. Civil rights, on the other hand, which we'll talk about next week, the government serves as the gatekeeper in that scenario. They decide who has the rights and who does not have the rights. So voting rights is a really good example. Over time, the government has decided to open up the gate periodically and let more people come in and have rights. So those are the key distinctions that I'd like you to be aware of between civil liberties and civil rights. You will see this question on the exam. Now, briefly, to help frame the lecture for today, the Federalists and the Anti-Federalists were not on the same page when it came to the inclusion of a Bill of Rights on the United States Constitution. Particularly, the Federalists were opposed to including a Bill of Rights in the U.S. Constitution because states already had a Bill of Rights on their state constitutions. They did not want a national Bill of Rights to be either redundant or contradictory. They were particularly afraid of this fear of enumeration. What if we leave something off? You know, it's only 1780. Can we possibly envision all of the rights people will be entitled to? And they wanted the Constitution to be a document that lasted for centuries and centuries. So they were particularly skeptical of listing out people's rights and leaving something off because they did not want it to be construed that just because it was not on the list did not mean that it was not a right. If this is a little confusing, don't worry, we'll circle back to this at the end of the lecture. Now, the Anti-Federalists were adamant about a Bill of Rights being added to the Constitution. They believed that without one, the federal government would be far too powerful. It would secure individual liberties and would serve as a critical mechanism to hold the federal government accountable. Now, I'm not going to belabor the point too much here. I'm sure the Bill of Rights have been beaten over your head since you were about in middle school, so I'm not going to go through all of these in too terrible detail, but the point that I really want to call out here is that each of these is prefaced with the language, Congress shall make no law. Congress shall make no law infringing on your right to free speech, your right to bear arms, etc., etc. But it said nothing about what the state governments should do or not do. By the language of the Bill of Rights, Congress can't make any laws to abridge your rights here, but it doesn't say anything about the states doing it. And that's exactly what we're talking about today. This process of selective incorporation by which the liberties spelled out in the Bill of Rights became applicable not only to the United States Congress, but also to the state governments. Now, all of this was made possible by the 14th Amendment, which started the selective incorporation process anyway, but don't worry, we're going to get back to that next week. Today, I just want to talk about some of the instrumental court cases that made the Bill of Rights apply to the state governments. All right, now buckle up everybody because we're about to enter the lightning round. I'm going to go over how the most important amendments in the Bill of Rights came to apply to the state governments through some of the most well-known court cases in our history. Okay, so the First Amendment obviously covers your right to free speech, your right to assemble, the right to a free press, religion, petition, protest, all of these different things. We could have one whole class just on court cases on the First Amendment, so I'm not going to try to belabor the point here, and there's no specific court cases I want you to remember for the First Amendment just because there's so many, but what I do want you to know is that there are no absolutes. That is the one thing that I want you to take away from this. So yes, there are two specific clauses in the First Amendment that state Congress shall not make laws that either establish a specific religion or prohibit people from the free exercising of a specific religion. Yes, but that does not mean that Congress has no power to regulate any issues pertaining to religion whatsoever. So for instance, mandating school prayer is a violation of your religious rights. Neither Congress nor state governments can make you say prayers in school. But on the other hand, religious displays on public property, so like nativity scenes at courthouses, that's totally okay. States that engage in this are breaking no laws. So the point that I'm trying to illustrate here is that, yes, Congress cannot pass laws that establish any specific religions or prohibit you from exercising those religions. So the point I'm trying to make here broadly is that yes, Congress cannot pass laws that favor one religion over the other, but that doesn't mean that they're helpless in these areas. Just like free speech, there are no absolutes. Not all speech is free speech. There are some types of speech that are rarely protected in the court of law. Fighting words, defamation, obscenity, these are far less free forms of speech than, say, political speech, symbolic speech, or freedom of assembly. So just keep that in mind. There are no absolutes, and particularly when we enter the legal world, everything is up for interpretation. In 1975, Washington, D.C. passed a law banning its residents from owning handguns. In 2002, a bunch of people got together and said, hey, you're violating the Second Amendment. And then ultimately, the Supreme Court steps in and says, oops, yep, you're right, my bad. But D.C. is just a federal enclave and not a state, so the ruling didn't apply to all the states. It only applied to Washington, D.C. So basically, you had the same exact court case in Chicago 2 years later, which decided the same thing, so now the Second Amendment applies to states too. The Fourth Amendment protects you against unreasonable search and seizure. Typically, police need a warrant to search your person, car, domicile, or property, but this is not always the case. Police can conduct a search without a warrant if they suspect unusual conduct, probable cause, plain view, or exigent circumstances are present. Basically meaning, if the police are driving by and they hear someone screaming from your house, they can enter your house without a warrant. However, when police do perform an unreasonable search, any evidence that is collected in that process is subject to the exclusionary rule. Now, this just basically means if evidence against you is obtained illegally, it cannot be used against you in the court of law. One of my favorite cases, Mapp versus Ohio, was the landmark case that made the exclusionary rule apply to state governments. Mapp's home was searched unlawfully, meaning that the police did not have a warrant or any exigent circumstance necessitating a search. Now, I'm glossing over a ton of details here, but during the search, police found a big old trunk of porn in her basement. I'm not joking. At the time, this was illegal to possess in the great state of Ohio. Mapp was charged with possession of lewd books and sentenced to 7 years. 7 years for having a box of porn. Can you believe that? Ultimately, the case made it all the way up to the United States Supreme Court, in which the justices ruled in a 6-3 decision that the exclusionary rule does apply to states. The police never had the authority to enter her home. Any evidence collected during an illegal search is inadmissible, and Mapp's conviction was overturned. The Fifth and Sixth Amendments have a ton of different legal protections in them. We don't have time to go over all of them in this lecture. I highly encourage you to read your textbook that has a really nice discussion on each of these. But one of the most recognizable clauses in the Fifth Amendment is the right to not incriminate yourself. Now, this is where we get the line, "I plead the Fifth," which people can invoke if they are fearful of incriminating themselves. And the Sixth Amendment is most notable for protecting your right to legal counsel. So one of the most notorious cases regarding the Fifth and Sixth Amendment is Miranda versus Arizona. And yes, this is where your Miranda rights come from. Let me give you a little background on this case. On March 13th, 1963, Ernesto Miranda was arrested by the Phoenix Police Department based on circumstantial evidence linking him to the kidnapping and rape of an 18-year-old woman. After 2 hours of interrogation by police officers, Miranda ultimately signs a confession to the rape charge. However, at no time was Miranda told of his right to counsel or his right to remain silent. At trial, when prosecutors offered Miranda's written confession as evidence, his court-appointed lawyer, Alvin Moore, objected that because of these facts, the confession was not truly voluntary and should be excluded. Moore's objection was overruled, and based on this confession and other evidence, Miranda was convicted of rape and kidnapping. He was sentenced to 20 to 30 years imprisonment for each charge. 3 years later, the case makes it all the way up to the Supreme Court, where the ruling is issued that, quote, no confession could be admissible under the Fifth Amendment self-incrimination clause and the Sixth Amendment right to an attorney unless a suspect has been made aware of his rights and the suspect has then waived those rights. Because Miranda was never made aware of those rights, the conviction was overturned and he was released from prison. However, a year later, Miranda was retried with different evidence and witness testimony and ultimately convicted of the charges. He was sentenced to 13 years, but was paroled by 1972. And just in case you were ever wondering what happened to Miranda after he was paroled in 1972, well, 4 years later, after he got out of jail, he was stabbed to death in a local bar where he frequently autographed Miranda warning cards. Fun fact. The Eighth Amendment protects Americans against Congress establishing laws that enforce cruel and unusual punishments. And well, since death is a pretty cruel and unusual punishment, let's talk about the death penalty. Now, you may be surprised to learn that for a brief period in the 1970s, the Supreme Court actually banned the death penalty in the United States. So why do we still have it today? Let's do another case briefing. 1972, Furman v. Georgia was the landmark Supreme Court case that ended the death penalty, albeit briefly, in the United States. Now, according to the case brief, in 1972, a Georgia resident awoke in the middle of the night to his house being burglarized by this man, William Henry Furman. Now, according to Furman's own account, once he was caught by the resident, he tried to escape, he ran, he tripped, and the firearm he was carrying went off and killed the resident. Accidentally. This is Furman's account, at least. So according to Georgia law at the time, this crime was eligible for the death penalty. Though it was never carried out, the case was appealed all the way to the United States Supreme Court, which conducted a thorough review of how the death penalty was implemented in the United States. Ultimately, the court found a disturbing pattern among states regarding the implementation of the death penalty. Specifically, they found that courts were much more likely to sentence black convicts to death, while white convicts who committed the same crimes would often receive far lesser punishments. This led the Supreme Court to define the conditions by which cruel and unusual punishment occurs. So most obviously, 1, a punishment is cruel and unusual when the punishment is carried out arbitrarily, and in the case of Furman v. Georgia, the color of one's skin cannot be the determining factor of capital punishment, because it is in fact arbitrary. 2nd, punishment is cruel and unusual when it is degrading to human dignity or excessive physical suffering. 3rd, punishment is cruel and unusual if the mechanism is widely rejected throughout society, such as public disembowelment, being drawn and quartered, burning at the stake, etc. And finally, punishment is cruel and unusual when it is patently unnecessary or if there is no reason to inflict said punishment. In other words, you don't deserve the death penalty if you ran a red light. So, over the next 4 years, 37 states enacted new death penalty laws intended to overcome the court's concerns about the arbitrary imposition of the death penalty. Now, this is one of my favorite games to play in politics, and it's called Find the Loophole. So just to recap, in 1972, the Supreme Court says the death penalty is illegal now, because y'all can't act right. Then the states say, it's only illegal if we arbitrarily sentence people to death. And what I love here is that essentially you have states saying to the Supreme Court, we will be so fair in deciding who we kill. So as long as states can justify that their new death penalty laws do not violate any of those 4 points outlined from the Supreme Court in the Furman v. Georgia case, and that these laws do not arbitrarily enforce the death penalty, these laws are perfectly 100% legal in the eyes of the government. Now, remember at the beginning of the lecture when we were talking about the Federalists and they said, hey, we're really hesitant to include a Bill of Rights in the United States Constitution because what if we leave something out? people might think that then it's not really a right. That's where we get to the Ninth Amendment. The Ninth Amendment states, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." So basically, this was the founders' really sly way of saying, hey, sorry, if we forgot anything, it's still a right, okay? Definitely not a right just because we forgot it. So what exactly does this look like in practice? Well, nowhere in the Constitution or the Bill of Rights do we see any given right to abortion, so this is a prime example of where the Ninth Amendment comes in. Since Roe v. Wade, the legal fight against abortion has raged in this country. Just as states scrambled to rewrite their laws to make the death penalty legal after Furman v. Georgia, states also rushed to place various restrictions on abortions in the aftermath of the Roe v. Wade court decision. Here, the find the loophole game is strong. Such state laws included, but were not limited to, women requiring consent from a spouse or parent before an abortion may be performed. Public funds or taxpayer dollars may not be used to fund non-therapeutic abortions. Women must wait 24 hours after listening to a heartbeat or viewing an ultrasound before an abortion may be legally performed. You may have also even recently heard about the wave of new laws just passed last year, referred to as heartbeat bills, in which many states pass laws banning abortions after a heartbeat can be detected from the fetus. Now, I don't know how many of you are aspiring obstetricians here, but these laws have received significant pushback because it usually takes most women about 6 to 7 weeks to even realize that they're pregnant, which just so happens to be the same exact amount of time it usually takes to detect a fetal heartbeat. Another topic within the realm of the Ninth Amendment pertains to the rights of the LGBTQ+ community. Well into the 1980s, 1990s, and early 2000s, many states had sodomy laws, meaning that certain sexual acts are considered crimes, on the books. These laws have a long history of targeting the LGBTQ community. Bowers v. Hardwick is a fascinating case out of Atlanta, Georgia, where the Supreme Court actually upheld that the state's sodomy law was legal. Long story short, the police entered the residence of Michael Hardwick to serve him a warrant when they found him engaged in a consensual sexual act with another man, and he was arrested on the spot for having consensual sex in his home with another man. Now, listen to this. The majority opinion by Justice Byron White reasoned that the Constitution did not confer a fundamental right to engage in homosexual sodomy. A concurring opinion by Chief Justice Warren Burger cited the, quote, ancient roots of prohibitions against homosexual sex, quoting William Blackstone, who, by the way, lived in the 1760s and believed that married women weren't legally people, so yeah, maybe not the best person to quote, quoted Blackstone's description of homosexual sex as, quote, an infamous crime against nature, worse than rape, and a crime not fit to be named. Burger concluded, quote, to hold that the act of homosexual sodomy is somehow protected as a fundamental right would be to cast aside millennia of moral teaching. And this was written in the 1980s. It's just insane. Almost 2 decades later, 2003, the Supreme Court reversed its ruling from the Bowers case in Lawrence v. Texas, ruling that sodomy laws were unconstitutional and violated a right to privacy as understood by the Ninth Amendment. Okay guys, lightning round is over. I usually spend 2 whole lectures just talking about all of this material. I know we can't really do that in this particular time, but I hope you enjoyed. I just want to leave you with a final few thoughts to get you thinking about the material. These are really good questions to think about that you'll likely see again on the exam or in the unit discussion boards. So let's take a look at these real quick. Know the definition of civil liberties. Civil liberties are individual protections from government restriction. Know about the debate of the Bill of Rights between the Federalists and the Anti-Federalists, specifically that Federalists were hesitant to include a Bill of Rights because of that enumeration problem. Keep in mind that the Bill of Rights originally did not apply to state governments, only to Congress. Know that selective incorporation is the process by which the Bill of Rights became applicable to the states. Now, I did mention that selective incorporation is a function of the 14th Amendment. We didn't talk about that today because that's more of a aftermath of civil rights issues. So we'll talk about that next week. And throughout the selective incorporation process, we see state governments infringing on a variety of civil liberties, including freedom of religion, due process, right to privacy, right? That was the content of all of today's lecture. Overall, the Bill of Rights paints a picture of our core civil liberty protections, while the Supreme Court interpretation of those liberties continues to define the limits of those protections. All right, guys, that's it for today's lecture. I hope you enjoyed. Stay healthy, stay safe, and as always, thanks for watching.